In this presentation on the dangers of no contest clauses, I explain that no contest clauses are often used to protect lazy and dishonest fiduciaries. The word fiduciaries is simply the legal name for executors or trustees, the people you name to manage your estate or trust after your death. Lazy and dishonest fiduciaries commit abuse and fraud, and then hide behind no contest clauses, knowing that beneficiaries will be reluctant to contest the fiduciary's dishonest actions for fear of being disinherited. That is, fiduciaries can be dishonest knowing that no contest clauses protect them from being exposed as abusive, lazy, and dishonest. Dishonest fiduciaries can use no contest clauses to threaten honest beneficiaries with disinheritance if the honest beneficiaries ever attack the lazy, dishonest, and abusive fiduciaries. In the first presentation in this series, I refer to 300+ court contests involving no contest clauses. When you read these cases, you will see that the real problem in inheritance conflicts is most often not disgruntled or entitled beneficiaries. The real problem in most inheritance conflicts is a dictator family fiduciary who abuses and misuses his or her authority and access to assets. This is a fact recognized by the courts. As just one example, the Georgia Supreme Court held that, quote, as a matter of public policy, in terrorem clauses may not be construed so as to immunize a fiduciary from the law that imposes certain duties upon and otherwise governs the actions of such fiduciaries. In other words, no contest clauses cannot be used to protect lazy or dishonest fiduciaries from doing their duties. The implication in this case is that it is the fiduciaries who are often the problem in inheritance conflicts. I point out in the articles and blogs on my site that no contest clauses are often used by fiduciaries to abuse and defraud honest beneficiaries. I also explain how they do it. So when someone asks me, what can it hurt to put a no contest clause in a document, my answer is that it can hurt a great deal. A no contest clause protects the very individuals who should be protecting the beneficiaries from their own abusive conduct. Unfortunately, some of you benefactors, some of you thinking about preparing your own estate planning, are often quite enamored with no contest clauses. Some of you may like the idea for one or more of the following reasons. 1. A no contest clause resolves your anger toward hostile heirs. If my bleepity son even thinks about creating any more problems, he's out. He's out. A no contest clause may satisfy some ongoing frustration with a difficult child or other beneficiary. Or 2, you hope that with this simple solution, this simple no contest provision, you are eliminating everything related to litigation. You are cutting out those nasty attorneys and unjust judges and all the cost and mess associated with inheritance conflicts. This hope may be very attractive to you, so you put in the clause and hope. 3. A no contest clause may be attractive to you because it is so simple. The whole concept is simple. It is so simple it is almost too good to be true. Yes, in fact, it is too good to be true. A brutal fact that will be too late to correct after you are gone. Now, your good fiduciaries, your executors and trustees, when faced with the temptations to abuse or misuse their authority, will be thrilled with a no contest clause. The clause is like a super shield around them, making them impervious to attacks, giving them power to do exactly as they wish without any fear of consequences. The no contest clause protects them from having to fulfill any duties, account to anyone, or follow proper procedures in administering an estate or trust. It's the best of worlds. The fiduciaries have unfettered access to assets, can pay themselves exorbitant fees, and lord it over the poor beneficiaries. Consider the following examples. First example, you may have signed a will or trust, but when you are fatigued or mentally slow or even mentally incapacitated, it is not impossible that someone may persuade you to sign a document, a new will for instance, and you don't even know it is a new will. It is already difficult under the law to prove whether a person's will has been fraudulently signed. A no contest clause makes it even more difficult for beneficiaries to prove a document is really not your will. Honest beneficiaries may know a destructive fiduciary is dishonest, and they may be convinced their evidence of such dishonesty is compelling. Unfortunately, the evidence of these honest individuals usually consists of self-serving statements that Mom would never have wanted to change her will like that, or Dad told his neighbor 2 weeks before he died that everything was being equally divided. Unfortunately, honest beneficiaries rarely have independent, verifiable, unambiguous, written, documentary evidence or proof of fraud. A dishonest fiduciary or dishonest beneficiary knows a court will not be impressed with the honest beneficiary's self-serving statements. And they further know that most honest beneficiaries will not have the kind of evidence a court must have to find fraud. What is so disturbing is that a no contest clause hinders honest beneficiaries in presenting even independent, verifiable proof of fraud. Second example, suppose you have retained an incompetent attorney who prepares a trust, someone recommended on an online legal document site. Suppose this network attorney prepares a typical cheap trust that includes the following cheap and dangerous provision. Quote, my trustee must distribute my assets to my beneficiaries as soon as possible after my death. And of course, the trust contains a cheap no contest clause. You die and 3 years goes by without your trustee distributing your assets, despite your statement that trust assets must be distributed as soon as possible. So, your honest beneficiaries sue the trustee. Your trustee promptly claims that the beneficiary should be disinherited for contesting the trust by questioning his interpretation of the phrase, as soon as possible. This happens. Third example. Suppose your honest beneficiaries believe the fiduciary is paying himself fees far in excess of what he is doing to earn those fees. Your honest beneficiaries demand an accounting, and the fiduciary promptly pulls out the no contest clause and claims the beneficiary should be disinherited for questioning his authority and actions. This happens. The brutal fact is that no contest clauses are often used by lazy and dishonest fiduciaries to abuse and defraud honest beneficiaries. My name is Craig Hughes. I am a probate litigator. That means I represent in court people who fight dishonest fiduciaries. I represent people who fight inheritance abuse and fraud. I am also an estate planning attorney. I assure you that fiduciaries often use no contest clauses to shield themselves from obligations to honestly and diligently administer assets or trusts, to shield themselves from fulfilling their fiduciary duties. More information about this brutal fact, including legal citations, is found on our website, www.estatesurpriseplanning.com.